Got it working, Christopher?
Um, yeah, we're still here. Justice Sellers?
Yes, sir. Can y'all hear me?
Okay. Yes,
Yes,
sir. How
I
are
hear
you
you
today?
great.
Good.
So, Justice Sellers, tell us, what is it like the average day life for an associate justice? Are y'all hearing cases every day or just certain days a week, or how's that work?
So we have things that go on every day. We don't hear cases in the same way that trial courts hear cases or have hearings. We have oral argument once a month. For instance, on this coming Wednesday, we have 3 cases that'll be orally argued in our courtroom. Typically, the first Wednesday of the month is when we hold oral argument. But the rest of the time, we are working on cases that are filed, working on some emergency things that come up, and any number of things like that. The Alabama Supreme Court gets a little bit shy of 1,000 cases filed a year. We only have oral argument on maybe 20 cases. So basically, and if you do the math, 980 cases are not orally argued. That means they're decided on what the lawyers have filed in their briefs. So most of the time we are reading briefs that have been filed with us. We are reading other justices' opinions about how we should rule on a case, or we're reading other justice memorandums that explain why we should affirm the trial court, or we're working on our opinions or our memorandums that will be circulated to the other court. And then we have a weekly miscellaneous docket that contains any number of matters. It could be administrative issues about, the court system. We also regulate the practice of law in Alabama, so we have to deal with lawyer disciplinary issues and things like that. So there are a lot of different moving parts that go on in a week that's not just like a trial court would hear cases and actually sit on a bench. Most of the time, I'm sitting exactly where I am right now in my office, reading things, working on things, writing things, and all of that.
Justice, I know recently the Alabama Supreme Court instructed the
So,
Alabama Bar Association to rewrite the rules on lawyer advertising. How exactly, what was going on that we felt that was necessary and what has changed?
Yeah, so here's, the bar, like other professional groups, is self-policing, and that members of the bar try to do things to not, discipline themselves and pass rules and regulations. So about, I'm going to say in 2018, when Sam Irby was the president of the Bar Association, one of Sam's initiatives was that we needed to look at the lawyer advertising rules. They hadn't been changed for 30, 40 years, maybe even longer than that. And as people may recall, it used to be that lawyers could not advertise at all, that there was an absolute prohibition against that. And the United States Supreme Court said, well, you can't do that because you can't restrain commercial speech, and lawyers are engaged in business. And so you can't restrict them from basically advertising. But since that time, as many people have noticed, and if lawyers have noticed, lawyer advertising has seemed to be more and more pervasive. And sometimes the things that are advertised may not be exactly as correct as they should be. And it's also come up that with the advent of the internet, there are various things that you could do to position your law firm over other law firms so that in initiating a search, the result would basically always come up, Brandon Mosley. You can pay for that. So if somebody said, criminal lawyer Brandon Mosley put up, if somebody said, something divorce lawyer Brandon Mosley would come. So trying to make it so that if lawyer advertising is to be permitted, that there are some restrictions on it, that the consumers are protected. So if somebody advertises, they recovered a judgment, that they in fact really did recover the judgment, and those sorts of things. So what happened is Mr. Irby had a study group task force with some really fine lawyers from all across the bar look into this issue. And they spent several years looking, proposing rules, looking at what other states had done and things like that. And so as a result, they had some proposed rules. We looked at some of those. They sent it for public comment. And so we just in the last month have promulgated new lawyer advertising rules to try to address some of these issues. I will say that my understanding is, and I haven't seen this, is that there's some law firms that are not happy with these new rules, and there's a possibility that our court and the Bar Association may be subject to some kind of suit that we are in these rules restraining people's ability to engage in commercial speech. So because that's at least been threatened, I don't want to say too much about the rules, except the whole idea is to make it so that consumers are protected, lawyers' rights of speech are protected, but that we're trying to regulate the practice of law in a positive way so the public knows that when they search for a lawyer or engage a lawyer, they truly have the level of expertise, competence, and experience to handle the case that they are advertising that they can actually handle.
Justice Sellers, when without going into like, a specific case or anything, can you give us like a hypothetical, like what y'all are looking for when like an appeal takes place? Is it like a mistake by a trial lawyer or judge or something like that?
So when an appeal comes in to our court and it's assigned to us, the first assignment is really in the clerk's office for the clerk to look at the case and make sure that jurisdictionally it meets all the criteria for to perfect an appeal. And then there are various procedural things that will happen before the case is actually assigned to any of us, not the least of which is compiling the record, which is not only the transcript of a hearing or trial, but it's also all the paper that got filed in the case. So when an appeal comes to us, both sides are represented. One side is unhappy, and so they're the ones that file an appeal. They're called the appellant. One side is happy, and they're called the appellee. And so our appellate process gives them a chance to review what a trial court did and have us assess whether the trial court abused its discretion, whether the trial court followed the law appropriately, or maybe, and it could be, and we have this happen, that in the course of a legal proceeding, maybe the legislature has changed something around, or there may be something else that has gone on, or the U.S. Supreme Court could have come in and done stuff. So when we get an appeal, the first thing that we're really looking at is to try to understand exactly what the issue is, and then look at the issue and see, well, did the trial court make a mistake? Because our court is a court of review. We're not a court of original jurisdiction in that cases are not initially filed with us. The cases that come to us have already been heard by a court somewhere, sometimes more than one court. So when something comes to us, we're initially looking to see, did the trial court make a mistake? And sometimes, even though the trial court may make a mistake, the mistake is not material and it wouldn't have affected the outcome of the case. And so we don't want to just always say, well, the trial court made a mistake, so for every mistake you get a new trial. No, the mistake has to be consequential. It has to be material. It has to be something so that it caused an error that would have changed the outcome of the case. So those are some of the things that we are generally looking for. But every case is a little bit different, and there are different standards depending on the type of case that's filed of what we're looking for. But just overall, we want to make sure that the trial court did right, there's not an error, or if there is an error, the error was not so significant on material. Like, for instance, every now and then somebody will bring up something that's very insignificant. The trial court made a mistake. Maybe they called somebody by the wrong name. Maybe they let some evidence in that they shouldn't have let in. But the question is, was what the trial court did so material as the outcome of the case would have been changed significantly? And in that case, you'd probably send it back for a new trial. Other times you're looking and maybe a trial court didn't make the right call, but the record before us indicates what the right call could be, and we can simply go in and say, this is what the trial court should have done, and we'll send it back to the trial court based on our analysis of what the record is before us, depending on what the status of the case may be.
Justice, in 2020, we had the whole COVID pandemic.
Correct.
And a lot of the courts, I think most of the courts in the state were shut down
Right.
like a year. and we already had a little bit of a backlog in cases, civil, criminal, it's, what is the courts doing to try to, work down that backlog so people's child custody case or, in some extreme cases, that a murder case is heard, on
Yeah.
a more timely basis,
Yeah, so I'll tell you a couple things. So COVID was something we're all trying to forget about because it wasn't, it wasn't great, and we didn't know what we were getting into, and we did the best we can. I will say this for the Supreme Court side of this thing, we looked at COVID in March, made some decisions because we regulate the practice of law in the judicial system statewide. The first thing that we did is tell everybody, the court system can't be shut down. People are going to commit crimes. They're going to do inappropriate things that violate the law. So the court system can never shut down. So we have to make sure that we keep the court system open. And we were very fortunate in that our technology people were able to incorporate Zoom into our court case management system. That meant that while you may not be able to have a jury trial, you could at least have hearings, and the hearings could be conducted over Zoom. So nothing stood still, but we found a mechanism within really about 3 weeks of trying to incorporate technology so that cases could still move forward, even though jury trials would be more difficult and all that. From the Supreme Court side, once we saw what we thought COVID was, we started having oral arguments in our courtroom really in June after March, which I was very proud of our court for doing that. We had to do social distancing. We're following the rules that everybody tells us to do, 6 feet, you got to wear masks. So instead of being able to have, 200 people in our courtroom, I think we limited it to maybe 50 and spread things out. So we felt like by going forward and having hearings, oral argument in our court, that would set a good example. And I think that it did to some degree. Yes, there was a backlog, and a lot of times the worst backlog was in the criminal side of things, because if somebody is accused of a crime and indicted, they have a right to speedy trial. And so if you have court circuits that have both the criminal and the civil docket, that they're in a way combined, in the sense you don't have one judge that only does criminal, one judge that only does civil, they're combined. The criminal cases have to go forward first. And so that backlog has been, it's there. We have been helping to appoint judges, try to work that backlog down. From a criminal side, I'm very thankful that the legislature passed some legislation that the governor signed into law that allows, if there is a backlog in criminal cases, that the district attorney or the attorney general certifies that, and the chief justice can appoint extra judges to try to clear up that criminal backlog. So COVID was bad. Yes, it created a backlog. We've been working to try to cure that backlog. The problem that you've got, just like anything else, is that a lot of things are based on what schedules are that judges have, and some circuits have fewer judges, some need more judges. But now our chief justice has the ability to appoint special judges to try to reduce the criminal backlog, because, like anybody knows, if somebody's arrested and they're put in jail and they bond out, if they don't have a trial for 2 or 3 or 4 years, that doesn't really say a whole lot about the rule of law and keeping people accountable. If people are going to get arrested, the system needs to move forward relatively quickly for a resolution of, if they're not guilty, great. They're not guilty, we move forward. If they're guilty, then it takes them off the street. They get sentenced by a trial judge. But failing to act on those things quickly can encourage, in my opinion, crimes to be committed because people think there's no accountability. And I think some of the new legislation that Attorney General Marshall has been especially keen on is trying to do things so that if somebody sees that, hey, there are criminal cases that are stale, we need to go ahead and have judges appointed to move those things forward. It's unacceptable for dockets to be huge with criminal cases and them not to be handled. So I'm not going to say we're absolutely there yet, but we're working through and doing the best we can. as the final authority of the judicial system to make sure that circuits have the tools they need to clear their dockets, especially in the criminal side of things.
Justice Sellers, can you explain to some people who may not know how a federal judge can block a president's executive order or legislation that's passed by Congress?
I'm not sure that I can. I'm not a federal judge. I am a mere state court judge, and we don't typically handle things like that. I mean, the unique thing about our system is we do have a federal system, and federal judges are appointed for life. State court judges are elected, and federal judges do things that federal judges do. But the thing about that I would say is there is an appeals process. Is it the most efficient thing in the world? May not be as efficient as maybe we would like it. But if somebody's unhappy with what a federal judge does as far as blocking an executive order or blocking initiatives taken by the executive branch, there's always a way to appeal that. And in a number of times, appellate courts will reverse trial judges for exceeding their discretion, even abusing their discretion and all that. So I guess what I would say is, while I don't know that I can explain how the federal system may work, the perception is that, well, a federal trial judge made a decision, but that's not really the end of it. And our system of the rule of law, and because we do have appeal courts in the federal system, and the Alabama Supreme Court being the final appeal system in the state of Alabama, it takes time, but a number of instances, things do get reversed and the order gets upheld. Now, we have had situations in our court where state court judges have taken action to say that action taken by the executive branch is inappropriate or exceeds its authority. I mean, we have one situation, it was right before I got on the court, where we had a trial judge that tried to prevent a legislative committee from meeting. Well, that decision was appealed and it was reversed because we have a separation of power. We can't tell the legislature when they can meet or not meet, or goodness knows, we certainly can't tell them what their agenda ought to be or what they can do. So there are checks and balances that are built in. And while there's a lot of angst about federal judges and what they can or can't do, and the fact that they're appointed for life, that's the system that we have chosen. Overall, the system works. I've had cases that I won that I was surprised that I won. I've had cases that I lost that I was surprised that I lost them. But in balance, there is a system, and I think the system typically works and renders a legal judgment that provides some stability and some continuity. And so I would tell anybody that's concerned about what a trial judge does, just take a deep breath, let appeals get filed, let all these things get hashed out. And the other thing that I would tell, people too, is we do have three branches of government. And while the courts can't tell the legislature specifically what their agenda can be, the legislature can restrict the jurisdiction of a court. There are a lot of things the legislature can do. So our system is built not to be really efficient or necessarily effective, but is built to provide as much stability as we can, so we don't have large dislocations when courts rule or legislatures act. So if people are unhappy with it, they can appeal, but they also have a legislative option too. And I think those things are all properly explored, and they have created a legal system that I think is the envy of the world, because we do have appellate review. Some places don't have appellate review. So that's not a great answer, because federal system is its own world, but I think people ought to look at the whole system in context. And yeah, you can be disappointed that a federal judge ruled a certain way, but just know that that's not the last thing that's going to be said in that case. There'll be other chances for appeal. And then, we've had situations where even in Alabama, where the legislature has basically legislatively restricted what the court does and that sort of thing. So
on that note, in the Alabama legislature, I think Representative Kenneth Pascal pretty much regularly brings some sort of legislation that would limit what the civil judge could do in child custody cases
Mhm.
where, I mean, it's presumptive, a presumption that it would be joint custody if both parents are ruled fit. And generally the Judiciary Committee pushes back on that, arguing that the legislature, by passing that legislation, would be taking the discretion away from the trial judge. Is that a balance of powers deal, or could the legislature do what Representative Pascal wants it to do if he had the votes?
I mean, I think they can. The legislature restricts all kinds of things, but I think the bigger context is what I think you want to have in your judicial system is you want to have judges and that there's a consensus about who the judge ought to be, which is why I think electing judges in Alabama will always be the case. Every now and then somebody says, well, to appoint them. But if you have judges that are elected, that are accountable to the people, and everybody agrees those are capable, competent, rational people, I think you want to give them as much discretion as you can, because a lot of times I've seen in my past life, and I was a tax lawyer for 28 years and dealt with all kinds of fun things in the tax code and legislation and all that. Sometimes legislation in attempting to achieve a result or to solve a problem can sometimes have the opposite effect. And in closing a loophole, they could open a loophole. And so I think you have to be extremely careful when you enact legislation to make sure that it works holistically. You're not creating a larger problem. And I don't know about that specific piece of legislation, so I'm hesitant to say how that might or might not work. But overall, the legislature can do any number of things as far as regulating legislatively what the judicial system can do and various things like that. Now, they have to overlay all that, obviously, with what the Constitution says, and not only the state constitution, but the federal constitution. So there's certain, they can't do anything they want to. They have these constitutional guardrails. But I've just always cautioned people, be very careful when you're doing legislation to deal with problems, because you can solve a problem and after the legislation kind of germinates, there may be in paragraph 38 on page 59 a provision that may not be what everybody intended it. And if you had given the trial court discretion, that would be better. And I mean, when I did work in the federal system, one of the things the federal courts did is they promulgated sentencing guidelines to try to limit the discretion of trial judges as far as sentencing was done. And there were a lot of weeping, wailing, and gnashing of teeth about that. But that was something that has happened before, to try to make it so, all right, we want you to exercise discretion, but we're going to limit how much discretion that you can do. And so sentencing guidelines are one of those ways to make sure that there's a fairness, there's an overall fairness to the system that's consistent. So if somebody commits a crime in one place, the punishment should be virtually the same or within parameters that everybody can say are reasonable. But sometimes when you remove discretion, and there have been situations where people have done that with some laws, and all of a sudden you create a problem. And then because the legislature did it and the courts don't necessarily have the ability to reverse the legislation because it's not unconstitutional, the legislature has to go back and fix it. So I always think we should tread very carefully when we're enacting legislation that's trying to solve a particular problem, because if you think you're electing good people and they're supported by the majority, you ought to have enough confidence to give them the discretion to do what is in the best interest of the system and who the litigants are.
Justice Sellers, touching on your comment about justices or judges being elected and being held accountable to the people, are you concerned that there may be some judges that may go with the will of the people on cases instead of what they should do by the law?
Well, I mean, it's always a risk, but I think our system has guardrails, as I mentioned, built in. For instance, just because a judge is elected doesn't mean he or she can do anything they want to do. I mean, we have a system that regulates the conduct of judges. if somebody believes that a judge has acted inappropriately, they can file a complaint with the Judicial Inquiry Commission. Judicial Inquiry Commission can investigate them. If they think there's something that's gone on, they can try to work out a resolution with the judge. Or we've had trials where the judiciary meets and they suspend judges, withhold pay, and we've had judges removed from office. So I say all that to say that if they're not going to follow the law, and a judge gets to the point where they're clearly not following the law and there's some detrimental issues, then there's redress, and that somebody can get the Judicial Inquiry Commission to investigate what the judge has done, and then they could be fined, suspended, or removed from office. So those are the ways we build things in to make sure that you can't have a rogue judge who just goes and starts doing things and wandering away from what the rule of law is and what the Constitution says and what our system requires them to do.
I know you can't discuss an individual case that could come before the court, but in the, probably the biggest example of this is the current cannabis, litigation that's going on. There's a perception in the public that if you have enough money and you get an outcome, from a government agency or a court that you don't like, that with enough money, you can just keep throwing motions and briefs and keep it in the court so that you either get more chance to negotiate or a chance to legislate. You can drag things out in the court. Is that true to a point?
Well, let me answer your question this way, because there's an awful lot about medical cannabis that goes on, and the lower courts have issued some opinions about that. But here's what I'd say. I mean, I think in general, I don't think it's anything new. Throughout civilization, there's always been a perception that people that are wealthier than other people have greater control over the political system, which includes the judicial system. And so I think as judges, we have to be extremely careful. And one of the oaths that we talk about, is that, we're not to be respecters of persons. We're to follow the law. Now, is there perceptions are always going to be there, because people look and say, well, here's a lawyer that was appointed to represent this person convicted of this crime. They got convicted. And here's the son of a wealthy person. They hired the most expensive trial team and they got off. I'm not so sure you can compare that, but that's the perception that's out there, and it's regrettable. But the other thing that I would comment on is, I think overall, I think the challenge that we have in our legal system is this unfortunate idea of lawfare, that you don't really engage in, direct action anymore, but you use the legal system to do things, to delay, to deny, sometimes to even, deceive, because the legal system assumes that everybody's an honest broker. That the lawyers are honest brokers, and that they're going to do, we have to say we don't want lawyers to zealously represent their clients, but they also owe a duty to the court and to the Constitution and things like that. And so if there's a perception about people having more money to delay it, I think that perception's bad. I think we should do what we can to make sure that perception doesn't linger. But I think we also have to make sure that lawyers have not only a fidelity to their client, but also to the legal system. And I think if people are engaged in gaming the system and doing things that are inappropriate, that really aren't in the best interest of justice, I think that's a problem. And I think we've seen in some ways that there are possibilities that exist. And so another part of the work that we do is regulating the practice of law. And if somebody sees a lawyer who's misbehaving or done things inappropriately, they have the ability to file a complaint with the Bar Association, to let the Bar Association investigate it, and the Bar Association suspends lawyers. The Alabama Supreme Court is the final arbiter of that punishment, and either confirming or changing the punishment or sending it back and all that. But I think if people are gaming the system in an incorrect, inappropriate way that uses the law and is not loyal to the court system and to honesty, then I think they've got a problem. Now, there have been in the last year lawyers who have got in trouble for doing things like this, where they have tried to game the system for their clients, and there are lawyers who have been fined and otherwise disciplined. So sometimes those cases don't necessarily get reported, but they do happen and get investigated. And if somebody determines, and it's not a simple procedure, that a lawyer's done that, then they can get suspended and in an extreme case disbarred.
Justice Sellers, let me get your opinion on something I've always wondered about. If me and Brandon got charged with murder, the jury probably convict us in 2 minutes. But we've seen people like get starstruck with juries, like the Menendez boys, Casey Anthony. Do you think it has to do with these people's looks, or do you have an opinion on that? Why the jury seems to get enamored with some defendants?
There's a whole science of jury consultants, how to appeal to a jury, and all that. In my experience, again, I have to go back to what I know. I was a tax lawyer, and the law does not allow tax cases to be tried in front of a jury. And I'll leave you to guess why that probably is. The only time this is a great trivia question, is the only tax case that can ever be tried in front of a jury is a property tax case. Any other tax case, the U.S. tax courts, there are no juries in tax cases. They are decided by a judge, and that's it. So that's my background. So I have very, very limited experience as far as juries, because I've never had to deal with a jury consultant on any big case, because I was going to get stuck with a judge that usually was a subject matter expert, which made the case, quite frankly, more more efficient. Why jurors maybe get enamored one way, how cases all of a sudden take on a life of their own and animate the public. Boy, I'm not sure that anybody knows exactly why that is. I mean, juries are people too. They have their own opinions. They bring their preconceived notions to the jury room and all that sort of stuff. I would say, though, in cases that I've looked at, and some other experience I've had since I've been on the court, typically a good trial judge knows how to manage the jury, to instruct the jury, to exclude things from the jury. And in my experience, when a jury starts to wander off and deal with things that are not germane to the actual lawsuit or other things like that, what that says to me is that the judge has maybe not been as effective a manager of the jury as they could have been, because that's essentially what a judge is supposed to do. But why jurors may think because somebody's more attractive than this and they ought to acquit them, is anybody's guess. And if you read some of the literature, and every now and then people provide this to us in their briefs, these jury consultants that are psychologists, sociologists, that measure what words should you use. If you're going to have a case, you want to make sure you use specific words if you're trying to advocate for one position versus another. So there's an art to this. There used to be, we have in Montgomery, where I live, we have the Alabama Shakespeare Festival, which is a wonderful place. But one of the actors there, as a side, he used to teach a course called Acting for Lawyers. And the whole idea was to show lawyers, you're acting in some way in front of a jury. You need to be thinking through how to have some emotional intelligence to sense what a jury's doing or not doing and how to respond. So there's a science to it. I'm probably the wrong person to give you a whole lot of insight about how juries work, because I was always stuck with a trial judge handling cases that I litigated.
For non-attorneys and people that aren't regularly involved in the court system, like law enforcement, there's a perception out there. Anytime you talk to the public, you run into this, where they think that, if you get pulled over and things go badly and you were doing something wrong that you shouldn't have been doing, and you can get locked up in the Alabama prison for like 20, 25 years. Could you go into how many things we've got, like community corrections, drug court, veterans court, to try to that, first or second, offense, nonviolent offender, where we try to route them somewhere other than being locked up for the next
Yeah.
20 years of their life in the prison
Yeah.
system?
Yes, I would say this. If you look at the cost to incarcerate somebody and the cost of the Department of Corrections over the last 10 years, it is staggering when you divide the cost of corrections by the number of people that are incarcerated in the prison system. And that's its own discussion and not something that I'm able to solve at all. So I think that if you look at how much it costs, incarcerating somebody is a failure on a number of levels. So to the extent that our court system can take nonviolent first offenders and give them community corrections, can give them a chance to engage in some community service activity, I think that is absolutely the best way to do it. The cost of that go down, the chance of reoffending go way down. And so that's what our system is trying to do. And as you may know from this last legislative session, we adopted a number of specialty courts that deal with veterans, that deal with, mental health issues. There's some people that if they are taking the medicine that's prescribed for their mental illness, they're fine, they're productive, they can be employed, they can be as normal as anybody else. But if they stop taking it or something comes up or they have an episode, then they engage in criminal behavior or behavior that lends itself to criminality. And so, yes, those types of courts make a huge difference because we, from a statewide citizen perspective, keeping people that don't need to be incarcerated out of that and giving them a second chance, providing them employment skill training, some of the wonderful things that go on in our community college system. Ingram State, it's part of, is connected with the, so that people are there and they're getting some training that they're going to be able to go and have a skill that is a marketable skill that can support them and a family. That's part of what we need to do. And so you're right, there's a holistic approach to criminality, and we certainly need to discover that. Unfortunately, our court system is somewhat limited in what we can do and what we're able to do. The legislature has seen fit to give us a little bit more leeway with that. But I think, to go back to your initial premise, if somebody gets pulled over and they're doing something wrong, I would say to anybody that has a perception you're going to go to prison for 20 years, I think that perception's wrong. Our system clearly says you're innocent until proven guilty. Along the lines of, if somebody's arrested, there are any number of potential interventions that can happen. I think the court system wants to supervise this to make sure that the system's actually working, because the worst thing we can do is give somebody community corrections or have them in a specialty court, but they're out in the general public, and have them reoffend and commit an even worse crime. So there's a real balancing with that. And again, if we have judges that are capable, competent, and give them the discretion, they should be able to look at somebody, size them up, figure out, is this person a good candidate for community corrections? Or are they somebody that really does need to go to prison, and in prison make it such that they can obtain a marketable skill? Because most people, even if you're locked up in prison, you're going to eventually get out. And we're not being smart if we don't realize that people are going to get out of prison. And if we give them a marketable skill and give them some training, they can be productive citizens. But there's some people, like anything else, they're never going to, there's no way to rehabilitate them. And a judge exercising discretion is the best person to figure that out.
Justice Sellers, touching on that a few years ago, I remember I got stopped, and the officer, I always laugh when they said that, they ask if there's anything on you that we need to know about. I'm always thinking, no, nothing you need to know about. Of course, I didn't. But he said, he said, would you mind if I patted you down? And I said, no. And he said, no, you wouldn't mind, or no, I can't. And I said, no, you can. I said, I do not submit to illegal searches, and this is a violation of the Fourth Amendment. And he said, have a good evening. Is there something, is there a probable cause guidelines that officers go by? When they're wanting, that gives them, they can go ahead and search somebody as opposed to him asking for consent and me denying it?
Well, I mean, there should be some kind of probable cause. I mean, you're not just subject anytime for somebody knocking on your door or stopping you and searching your car or whatever it is. I mean, there's got to be some idea that you've either committed an offense or you've done something, and there's a reason for that. And we've had a number of situations where there hasn't been probable cause, has been evidence, it's been obtained, and we've excluded the evidence because they didn't have probable cause. So, you know, uh, you need to have that. That's how the system works. Nobody should be subject to unreasonable search or seizure. On the other hand, if people are out in the public and they're engaging in behavior that looks suspicious, I think protecting the general public, we want to give policemen the ability to go and stop somebody and check and make sure they're not doing something that's wrong. So, when you live in a free society, there's always a balancing act between making sure I can have the largest amount of freedoms as possible versus making sure that I'm not in a situation where there's somebody that's going to harm me or my family or harm others, and the police have the ability to figure out what that happens to be. But people should not be subject to unreasonable search and seizures. I think, I've never been to the police academy in my world. I probably tried in my career maybe 5 criminal cases. The policemen that I've been in contact with, even when I was on the opposite side representing somebody that had been indicted, is I think the police are doing the best they can with the resources they have. And sometimes in their policing, we're asking them to make split-second decisions about, is this person's behavior, have they done something that could rise the level of probable cause that I need to check something else. You want the policeman to be able to do that within constitutional limitations. Now, if a policeman does something that he shouldn't have done, if he stops somebody inappropriately, if they engage in an unreasonable search and seizure, courts have the ability to review that. That means the evidence can be excluded, it can be thrown out, or it could be the whole case is dismissed because a policeman may have discovered evidence in an inappropriate way. But you want those balancing act. And I think the good thing about the example you gave me is that's a police officer exercising discretion. You said, no, you can't do this. And if you say, no, you can't search my car, the policeman then has to decide, do I want to go and get a warrant to search a car or a person? And that's another check and balance of our system. So somebody has to go before a judge and say, here's why I think I have probable cause. I saw them do this. I observed this. They can't just, act like they heard it through the grapevine or they heard a rumor. They've got to go to a judge, and the judge has then got to decide to issue the warrant. So we have a system that's got checks and balances. A policeman can never go and do whatever they want to do. And that's a good thing. But we also want to make sure in a critical situation, the policemen have the tools they can to make sure something bad doesn't happen or a criminal incident doesn't endanger the lives of normal citizens. So balancing all that out is a tough call. And we're asking policemen sometimes to balance those things. And a lot of times, they're making a decision very rapidly. And sometimes I think it's unfair for the court to review actions second by second by second in the time frame that we may have as a court versus a policeman who sees an incident and makes a decision. So that's a long answer to your question.
Justice Sellers, for people that don't know, before you were, a Supreme Court justice, you were a tax attorney. You were involved in a number of campaigns. You were like a key advisor to Kay Ivey when she was running for state treasurer and for lieutenant governor. In 2010, she was running for governor. I think Tim James, Bradley Byrne, Roy Moore, and some other folks were in that. Yeah,
Bentley.
obviously Robert Bentley. How difficult was it to make the decision in that campaign that we're probably not making the Republican primary runoff for governor. So let's switch races and go to the lieutenant governor deal, which she ultimately won both the GOP nomination and then lieutenant governorship over.
Yeah, so those are, I mean, political decisions are always hard. And sometimes you just have to be rational about it. And in the 2010, race, I believed in math and I believe in competent polling, and the governor was very fortunate in the lieutenant governor's race in 2020 that Kellyanne Conway was her pollster. And we ran some polls and realized that the path to success was going to be very, very difficult. And getting in the runoff was going to be very, very difficult. And if we switched to lieutenant governor, getting the Republican nomination would not be as difficult. We would then have to beat the incumbent lieutenant governor, who was Jim Folsom Jr. And it was a very, very difficult decision because you spend time campaigning for governor. You talk about running for governor and what you want to do, but there's a rational part. And I think one of the things that makes Kay Ivey the unique person she is the ability to look at facts and make decisions based on rational information. And in that case, running for lieutenant governor was not an easy decision, but she made it based on good data. And, I guess, the proof's in the pudding. It seems to have worked out, very well for her.
Just Sellers, touching on there, I remember the final poll they put out for that general election in the Birmingham Newsrail.com. She was behind Lieutenant Governor Folsom by about 7 or 8 points. Did your internal numbers show that, or did she just close that much in the final days?
No, I mean our internal numbers showed it was close. But it was 2010 was a Republican year. I mean, it was an off-year election. Barack Obama had only been in for a couple of years. There were a lot of things that were going on. And so the problem with statewide polls then, at least, was that they were sampling statewide. But what we did is we looked at 10 of the more contested House races and Senate races. And when we did that, that if somebody's in their local House race, which maybe has 5,000 or 6,000 people voting in it, maybe 10, I can't really remember. But that if the Republican in that race is going to win, and a lot of times beating an incumbent Democrat, the person that's voting is not all of a sudden going to switch and vote for the Democrat. So our internal polls showed it within about a couple of points. And one of the interesting, I guess, memorabilia from that campaign is I sent an email out to Kay Ivey supporters about 10 days out, and our polling said she was going to win probably by 52%. And I preserved that email. I think she gave me that email, and it's framed, and I have it, in a drawer somewhere in my office. But at least it's time stamped. It's not like, a Monday morning, quarterback who told you what was going to happen on Saturday and Sunday and all that. I've at least got a timestamp thing that showed that's what our internals, were showing, and it ended up being the case. But that was a fun, tough. It was a tough race, and she ran it, very well. Had to overcome a lot of obstacles because all the statewide polls show that she was down very significantly. But when you realize it was going to be a Republican year, and when you drill down into House and Senate races, if somebody's going to vote a House or Senate incumbent out, they're not going to go along with, a statewide incumbent. And that ended up being the case. So.
Lieutenant Governor, getting back to the courts deals, 50 years ago, if you had like a mental illness, they locked you up in a sanitarium. We had there were sanitariums all over the state. I mean, there were like thousands of people, like at Bryce's in Tuscaloosa. And since then, we've decided to go in the other direction and decrease the number of people, make it much harder to commit someone. And we've dismantled that ability to, if somebody's really having problems with life, with their friends and family being able to go to probate court and have them committed. I think there's a backlog of like a year, that where probate judges have, committed people, but there's no bed for them. How much of the crime problem is actually due to people that have a mental illness and they may be out here on the streets and in real life, self-medicating with narcotics, which wasn't really that big of an option 50 years ago. And so a lot of our perception of crime, being up is actually, the fact that, the mentally ill they're loose on the streets or they're being locked up in the jails. And, our sheriffs are having to, be psychiatrists as a part-time gig.
Yeah, I wish I could say that, number one, I had an answer, and number two, the court system could wave a wand and fix it all. It's just it's an ongoing, very difficult issue, and I'm not as up to speed on that because, from a standpoint, as a judge on the court, I only see what's before me. As a citizen, you hear about these things. There was a great consortium several months ago in Montgomery that UAB and their mental health team put on that had people talking about just this issue and how do we get mental health treatment, things like that, to people that need it. And yes, I've seen information about how many people are being locked up because there aren't enough beds and things like that. Unfortunately, our judicial system is ill-equipped to make those decisions. That's a legislative initiative. I will tell you this, based on the seminar that I went to a couple of months ago, just trying to educate myself on some of these things, is I do think that the Department of Mental Health in the state of Alabama is in very, very good hands. Lynn Bashir, who the Governor Ivey appointed, did an unbelievable job. And Kim Boswell, who is the current Commissioner of Mental Health, is just a hardworking, caring person, has a background in mental health, and has done a remarkable job. But like most problems, resources are limited, and you can't solve every problem you would like to. And so you have to do the best that you can. And unfortunately, the best that we can is what we're doing. Everybody will tell you, if we just had more money, and there's nothing that, the court can't wave a wand again and say, okay, you get more money. Unfortunately, our court system deals with the problems where people have committed a crime, and they probably wouldn't have committed the crime if they were taking their medicine or getting their treatment or attending whatever therapy sessions they needed to. But unfortunately, we don't get a chance to read that into it. They committed a crime. If it's proven they did, we don't have a choice. But this goes back to your initial question. To the extent that we have mental health courts, a court could take jurisdiction over that particular person, supervise them, make sure they're getting their medications, make sure they're getting their therapeutic sessions, making sure they're doing these things they need to do, and then we can be better for that. So there's not really a whole lot we can do specifically, but overall, I think your assessment seems to be correct, and that there are people that have mental health issues. And if we treated those, we wouldn't have to treat them from a criminal standpoint. We wouldn't have to have them in county jails and all of that. But there are not enough resources, and we're doing the best we can. And I'm afraid that's just the best we're going to be able to do right now.
Just so I got one more question for you. It's kind of an ask you question, I guess. But it's a topic that's I love a lot. I admin a couple Civil War groups. Do you think that constitutionally the South had a right to secede?
Well, I'm a historian to some degree, and I mean, revisiting all those issues about, the right to succeed. No, I don't think the South had a right to succeed. I think if you look at the Constitution and what the Constitution said and what the states committed to, there's a balance there. And I think there were better ways to address their grievances. I'm not so sure succeeding in the way they did was necessarily a great idea. Andrew Jackson, very much, a Southerner, and he gets all kinds of, well, he gets a little bit better press now. But one of the things that Andrew Jackson was absolutely committed to is that we had to maintain the Union. The strength of our country in the Union was very, very, very important. And I think if you go back and look at some of those debates, I think you can see the wisdom of all that. Simply from a standpoint of anybody making a rational decision, looking at the nature of what the world was like in 1861, you don't go fight an industrial part of the country with an agrarian part of the country and think you're really going to be able to win. It just, I mean, I hate to say it, but it reminds me of really, World War II. The industrial might of the United States is absolutely unbelievable. We don't really like to fight wars. We try to get in and get out and move on. We're not real warmongering kind of people. But once you get us agitated, we can build more tanks and more planes and more ammunition and weapons than anybody could cope with. And you look at what we do when we get our dander up as a country, and we can outproduce any place in the world. And unfortunately, I think the Civil War is indicative of, a lot of hope and not analyzing the situation with these people. The North has all these industrial, and all they got to do is turn that around. I sure would try to negotiate my way out of that than kill a bunch of people. And at the end of the day, you caused more carnage and more destruction than if you had tried to work something out. But the history of all that's absolutely fascinating. It's a great debate, and to read, the John C. Calhoun things, the Edmund Ruffin comments, and other people at the time, you get a sense of some very, very strong feelings. And in my mind, I think you hope in decisions that we make that people looking at the big picture are in a position to decide. So,
Justice, we've held you for about an hour here. Is there something you'd like to add? Because I'm kind of out of questions.
no, I just appreciate the opportunity. I'm always happy to, address people that want to talk about some of these fun things. So thank you for the opportunity to be on your program, and look forward to Brandon. I guess I'll run into you, in different places in Montgomery, and always good to see you, and thank you for the opportunity. But I have no agenda, nothing to say, except I will say this. I appreciate the twice the people of Alabama have elected me, and I look forward to continuing to serve the people of Alabama. The Supreme Court is a wonderful opportunity and privilege for me that I never thought I would ever attain, never really thought that much about it, but I love the work that I do, and I'm grateful for the governor for appointing me, but the people for reelecting me twice. So thank you very much.
Let's give him one more. Could we see Justice Sellers maybe be Senator Sellers one day, or
Nope.
Congressman Sellers, or
No, Justice Sellers is very, very content on the Alabama Supreme Court. We do great work here, and I love what I do. And I can't think of doing anything else other than exactly what I do day in and day out. It is very rewarding, and I'm grateful for the opportunity.
Thank you, Justice Sellers, for coming on and talking to us today.
Yeah, my pleasure. Y'all take care. Have a great weekend.
You too. Thanks.
Where is my invite? Okay. There we go. That was pretty good, Brandon.
Yeah, that went really well. I mean, we could have kept talking to him for an hour or so, and it was like, yeah.